Welcome to Life in the Law on ThinkTech Hawaii. I'm your host, Jay Fidell. Today, we'll talk about what is left of the United States Constitution. What provisions are now at greatest risk? And our guest for the show is Avi Soifer, formerly the Dean of the William S. Richardson School of Law and a constitutional scholar. Welcome to the show, Avi.
Thank you, Jay. It's good to be back. Always good to talk to you about constitutional law and many other things.
People don't realize how the Supreme Court has changed the Constitution, the government, and the law in this country, and how the Roberts Court is likely to continue to undermine the Constitution, the government, and the rule of law going forward. It's therefore very important that we follow and speak out on what they are doing. So, Avi, I would like if you could help us understand what is going on in the Supreme Court. What constitutional provisions have been undermined or effectively repealed or rewritten out of whole cloth, and on what legal, political, or ideological grounds, if any? Can you tell us what troubles you most about the cases, say, starting with Dobbs?
Well, thank you for that opportunity. I would first propose amending your title for this discussion. It is what is right of the Constitution. The answer is the U.S. Supreme Court. They are far to the right of what the Constitution actually provides. So, starting with Dobbs, that's the overruling of a key precedent, Roe versus Wade, and the court was delighted to overrule it and decided it was wrong, and all the Supreme Court justices who had followed it in the intervening 50 years or so had gotten it wrong, because now the court understands that there are only two ways that you can identify a right that's fundamental. And those two ways, if it's in the text, there's nothing about abortion or women or lots of other rights in the text, or if it's a deeply rooted tradition. Great irony of that is the current disputes, including before the court this term, about the role of parents in schools and school libraries and libraries in general. There's nothing about parental rights in the text, or in terms of women, deeply rooted because mothers did not have rights in the 19th century. So this is problematic. It's deeply problematic if you actually look at the text of the Constitution, which the current court from time to time alleges it's doing, because the Ninth Amendment says that the rights we've just listed are not all the rights. There are also other rights. So, excuse me, where did that test of text or deeply rooted come from? And the Ninth Amendment is so scary that it's never been the basis of a U.S. Supreme Court decision. It's been referred to, maybe a rule of construction somewhat, but it's never the basis until this day of any U.S. Supreme Court decision. So a lot has changed in this court, and they are delighted to ignore the rules of the road. And that's, I think, most evident recently in a series of cases that ignore the procedural rules. A lot of people think, and Thurgood Marshall used to tell his clerks, that if we don't have the rules, we don't have anything. So we need the rules of procedure. Even if a clerk came to him and said, Justice, this is one of your most important rights that they're violating here, and they filed a day late or whatever, and he would point to his commission and say, don't tell me what I got to do. If we don't have the rules, then they have all the power. And so the rules, we like to think, matter somewhat. And they are saying, well, this is a temporary restraining order. This is involving some of the cases in terms of what the Trumpists are up to. But we'll treat it like a preliminary injunction. TRO, temporary restraining order, is supposed to just sort of freeze things, the status quo, and it's not appealable. They decided, well, yeah, we're going to say it's like an injunction, and so it's appealable, and so we can reverse what the courts have been doing, the courts below. And there's a lot of ignoring of what the courts below are doing.
This is not good. When public confidence in the judiciary is on the wane, and when those courts are trying, the courts below are trying so hard to maintain a balance in government. Anyway, since Dobbs, there have been other troubling cases. What comes to mind?
Well, one of them, and I'm afraid that Chief Justice Roberts is involved in a lot of these that I'm about to describe, because we really do need him, if you count noses on the court, to stand up to the Trump onslaught and the Trump ignoring or demeaning the rule of law. But he didn't do so well himself in Shelby County, for example. So Shelby County is a decision about the key provision of the Voting Rights Act of 1965. People fought and died for that right, for the rights that were protected in that statute. It was probably in part because Kennedy was assassinated that LBJ, with the help of Ev Dirksen and others, bipartisan support, got the Voting Rights Act passed. And what the court, through Chief Justice Roberts, says is, well, that was really important at the time. It's true. People couldn't vote. That was largely based on race, but we don't need it anymore. So everything's okay now, and therefore it's unconstitutional. And in the course of getting to that, he paraphrases the 10th Amendment in one sentence because there is not much constitutional text that supports states' rights, but he's very concerned about states' rights or state sovereignty. So his paraphrase makes two crucial mistakes or paraphrases incorrectly in a way that would get a law student in some trouble. He says the rights not specifically uh, granted to Congress are reserved to the states or to the citizens. Doesn't say specifically. The Articles of Confederation did say explicitly, specifically. That's one of the things that James Madison and others fought against. There were 3 attempts to put it in. They said, no, we don't want that. We want more power in the National Congress. Secondly, it doesn't reserve, it's this kind of little slip, maybe sloppy clerk, but I don't think so. It doesn't say rights reserved to the citizens. It says the people. And these days, the distinction seems to be of great importance at the Supreme Court and the lower courts when we are rounding up people and sending them off to barbaric prisons. So, citizens versus people, can that be just a slip? I don't think so. He also has said for the court, well, it's true that partisanship and gerrymandering, it's bad stuff, but we don't really have the standards in which we can do something about that. So if your claim is that a very dominant majority in your state has gerrymandered, has played around with the map to favor themselves, to choose the voters rather than the reverse, that's okay. We can't do anything about it. There's an exception for race, but even that has become much harder to prove. One of the key cases we haven't heard decision in this term of the Supreme Court involves Louisiana and whether race was the dominant criterion being used in reapportioning the Louisiana uh, districts. And that's a very important question, but it's really hard to prove that it was but for race, which is what they seem to be saying, because there are always many reasons, including, of course,
Mhm.
partisanship. So those are
Mhm.
2 of many. And I think so far we don't have the shoe dropping in birthright citizenship, for example, which they presumably will decide this term. The argument was just a couple of weeks ago. Um, we have the free exercise clause run rampant and run riot, and the establishment clause all but disappearing because a majority of the court favors religion and disfavors the notion that the separation of church and state is important. So we have a very important case involving Catholic charities in the state of Wisconsin. They are claiming the same tax exemption as churches and synagogues and mosques get. They say, well, we're doing the Lord's work as well. If they grant that argument, then think about the consequences. All you have to do is say, we're doing this for religious reasons, like helping the poor, and you get a tax exemption. So it has radical possibilities. And I don't think one can be optimistic that they're going to say, oh, that goes too far. We'll have to wait and see.
Yeah, on top of that, Trump has kind of set it up so that he can deny a tax exemption or revoke one. So, you get sort of a tax exemption by personal discretion for anyone. Let me go back to my favorite 14th Amendment, last sentence, Section 3, regarding disqualification for being in an insurrection. It seems so clear from the plain English language of the 14th Amendment that Trump was disqualified from running. And yet, they effectively repealed that section, that Section 3 of the 14th Amendment. That was very troubling. Does that trouble you too?
It certainly does. And one of the things that I think underscores your point is that there had been fact finding, there had been a trial. Those things are supposed to matter when cases go up on appeal. And in Colorado, they had the fact finding and they decided that the role of Donald Trump in the insurrection of January 6th was important, and therefore his name ought not be on the ballot in Colorado. And because that was very early in the term of the court, last term, this is not this one. This is, I guess, in October, if I remember right. So the court said, "Oh no," they wanted to make sure that Trump wound up on the ballot everywhere. And so, no, we can't just accept what the Colorado uh, Supreme Court has said, even though that's what the constitutional text and practice points to. There has to be a vote by Congress. There's nothing in the Constitution that says that. And of course, they are case after case belittling or even ignoring the role of Congress when it comes to a whole bunch of other things like statutes that protect immigrants. No, there's an emergency and there's an invasion. And so we don't have to worry about what Congress has said since the 1790s. Uh, that immigration law, that's not really relevant, says Trump. And the court has basically gone along so far. We don't have, again, the final word on that. But the thing that really is kind of what bothersome or more is at the end of the term, we had Chief Justice Roberts writing for the court about presidential immunity. And without any support in the text, in history, in precedent, in policy, really, he decided that the unitary president was what somebody intended and that he went with it. So the president is absolutely immune for the things he does during his term of office. There's no support for that. And you may remember, I hope people remember, that Richard Nixon actually didn't defy the court ultimately. He resigned. He didn't just say, "Oh, I'm the president." He did say it actually, but it did not appeal to the public at the time. Uh, Harry Truman tried to seize the steel mills during the Korean War, and he said, "We need steel for bullets and guns. So I got to do this." The court said, "No, you can't do it," even though they were some of them his poker playing buddies, because they thought that on that question there were limits on the executive. And of course, the framers, if we want to worry about them, didn't like King George III very much. They were not saying, "Oh yeah, we really need a monarch or someone with the powers of a monarch." And we seem to have full circle now with a president who thinks that he is at least the king.
They put constraints. The Supreme Court put constraints on FDR and Humphrey's executor back in 1935. Can you talk about that? Can you talk about that? Is it still the law? Is it under attack?
It certainly is. And believe it or not, neither Jay nor I is old enough to remember that. But FDR, of course, passed a lot of laws. The Congress, for the most part, went along. The court often did not. And ultimately, that led to the court packing scheme in 1937. But the case you referred to was a couple of years earlier. But FDR is also already a very popular president. And the court said in that case, complicated, but they said, because the guy, it was his executor, it wasn't himself, he was no longer alive. They said, you can't just fire someone because you want to fire someone. There are protections. Now, that's before a lot of the current protections by the statutes and by administrative law, but it's an important decision. And the court seems willing to go along using the shadow docket, meaning they're not full arguments, to go along with a president who thinks, and certainly has said, as have his minions, it's against the policies of this president, therefore you're fired. And that's not just what Elon Musk did. That's what they are saying over and over again. They just fired, what would they do? They fire people daily. They just fired an advisory committee of historians to the State Department. So these are people who are doing public service and they're established historians. And they decided the whole bunch of them are out. Why are they out? Because they don't support the policies of this president. What they do support is history and the importance of history and of transparency about history. But this administration and the people who please the current executive are only people who think that our history is all golden and wonderful and there's never been a problem before. So if there are problems, you mentioned language, you mentioned people, we're going to eliminate them. They can't be part of the history any longer. It's astonishing what's going on in this country today. We've always been ahistorical as a people in the United States compared to many other, if not most or all other people. Tocqueville in the 1830s said if you took something away from an American that was his daily newspaper, Tocqueville saw that we were ahistorical. But the notion that we're going to clean up our history because it's only about grand history is really astonishing. And that is what this administration is trying to do. And they eliminate a board of advisors to the State Department about what can and can't be declassified from history.
They're changing textbooks, even in West Point. Extraordinary. They're deleting, references to, to civil rights and the like.
No, it's worse than that, Jay. I mean, they not just textbooks. They're telling they first the Navy removed hundreds of books from their library. And one of the things that is deeply ironic about that example is that in the decision, which is about affirmative action in universities and colleges, there is a footnote. This is a Roberts opinion. The Supreme Court strikes down affirmative action at Harvard and at the University of North Carolina, one private, one public. And they sort of grabbed the North Carolina case so it could be sweeping. Okay, putting aside whether that was appropriate, they've got the issue of affirmative action and admissions. It's only about admissions. There is no mention of DEI, for example, in that opinion. So it's only about admissions based on race. And in that opinion, footnote 4 by Chief Justice Roberts says whether this decision applies to the military academies is an open question. Because in the past, the court had emphasized the importance of affirmative action for the military. There were briefs by military leaders, and they had actually talked about that. So they're not overruling those, but they're also dropping a footnote saying, well, maybe, maybe not. Well, people have ignored that footnote. And there used to be a very important constitutional law footnote from 1938 in a case called Caroline Products. And in that case, the Supreme Court sort of set in motion what became a main page of the Warren Court's approach. And that was there are some people who can't rely on the political process to protect their rights. Their rights might be explicit in the Constitution. Their rights might not be adequately guaranteed. And it might be because they are a minority, a discrete and insular minority was the phrase. And so we are protecting, and of course they had in mind already the rights of Black Americans. We were talking about 1938. This is before Truman desegregated the military and so on. So the court is sort of pointing at that. They had a few cases that led them to say, we're going to have special scrutiny. We, the court, are going to look carefully at uses of the law which can't be changed by the political process. That's the famous footnote 4. We have a new famous footnote 4, the one ignored, as everyone has said, oh, DEI, as if everyone knows what that means, and we're going to just sweep across the country and eliminate all DEI, including going to law schools. I went to Georgetown before the publicity about Harvard, and they said, you got to change. This is actually this guy who is now in charge of pardons, Mr. Martin. So he writes to the dean of the Georgetown Law School, and he says, you're doing DEI at your law school, and unless you stop doing that, we can't tell you what it is. He doesn't say that, but they never do. You think about it, they've never told us what those words mean. And the equity part of it, law still has equity as a partner. We talk about cases in equity because the English law back in the mists of time was too harsh. And so equity came in to protect people on, you could say, moral grounds or religious grounds or things that were not appropriate for the harshness of the law. So equity is a good thing, and we still think it's a good thing. Well, there it is right in the middle of DEI. And nonetheless, we don't define it. It's void for vagueness as used by constitutional criterion. And getting back to what you said at the beginning, we really are in a situation in which the text doesn't matter and the constitutional crisis is not just one crisis. It's a whole bunch of crises because usually language that is so vague as DEI is attacked and successfully because it doesn't tell people what they're supposed to do. The law has to be more precise than that. It's called void for vagueness. There's also overbreadth. We won't go into that. First Amendment problems? Absolutely. Problems of the separation of powers? Look where we are right now in terms of Congress and the courts. And so we are talking about Fifth Amendment problems, Fourth Amendment problems, 14th Amendment problems for sure. I'm also an advocate of the 13th Amendment, meaning something. And as I said, that even the 10th Amendment, the kind of weak read for states' rights, is misparaphrased by the current court. So the constitutional text is at all times these days under attack or being undercut. Not to put too firm a point on
What about the Eighth Amendment, Avi?
it. Well, for sure, we are sending people to cruel and unusual punishment, aren't we? Those prisons, and we are now looking for other countries, right? We got a bunch of people on their way to the Sudan. We're not quite sure what to do with them. And of course, we ignore when the judge says you got to do something. You can't just do this. That judge in D.C., who is an expert on national security, there's a special court which decides whether or not there can be searches, warrants, and so on. He was the head of that court. He's the judge who says, wait a minute, you ignored my order to not have planes take off or have them turn around. He's still waiting. We're all still waiting. The court said, oh, you got to facilitate. We're still waiting for the court to do something about facilitating, which is their language, that the federal government, the executive, had to facilitate the return of people. Well, we're all still waiting. And they're, of course, suffering in a barbaric sounding, and it looks like, prison situation in another country. And then the court and the administration at first said, oh, there's nothing we can do about it because they're in another country. And the president of El Salvador comes to the White House and they are kind of making jokes and giving, humorous elbows to each other. And, oh, there's nothing we can do because that's where they are. They're in your jurisdiction. Well, in an interview about within a week, I think, the president says, oh, I could do it, but I won't. So you can or you can't. Well, we're not. So we're not following judicial orders. And people always talk about defying the court. What this administration has figured out is you don't have to overtly defy them. You just ignore what they say. And so far, even the U.S. Supreme Court has said you got to facilitate. And the lower courts have said over and over again in all sorts of ways, what you're doing is unconstitutional. And it hasn't made a difference.
So many other ways. By the way, you know that Trump is paying El Salvador for that prison service.
Yeah.
It doesn't come free.
Right.
And if
And
he
that's
stopped
why.
paying them, that would change the paradigm.
Right.
Well, let me ask you about the case that troubles me most, and that's Trump versus the United States, the immunity case. It's kind of a slightly vague, but what it does is gives him at least the argument of plenary immunity. And my question to you is, how does that change the country?
Well, I think we're seeing how it happens to change the country. And as long as there is not courage in the Congress, and of course, the Congress really is the very important parallel branch, if you will, uh, we don't know who's going to do anything. If the courts can just be ignored, uh, it is the case that President Trump wasn't in any way hindered, apparently, by two close calls on impeachment. So, what can you do to the executive? Well, that decision basically says for official acts, we, the court, I suppose, will ultimately decide that. But official acts, we're not going to tell you what that means. He cannot be sued. He cannot be made liable to the law. And that's astonishing. That's what I was talking about. The king can do no wrong, was very unpopular as a theory of law in the time of the American Revolution, because, of course, they didn't aim it at the Parliament. They aimed the Declaration and their objection primarily at King George. It was a an attractive villain, if you will. And Parliament, it was more complicated. They did have some friends in Parliament, but there was the king doing, in their view, terrible things. And so there was a moment when the court almost overruled that approach to immunity. And Justice Brennan said they should. And I think it was Rehnquist said, well, it doesn't really matter, doesn't go very far, but look where we are now with the immunity of the president. Now, actually, it's even left open that there might be more than official immunity by that decision. And as I said, there's no basis for that decision. There just isn't. And it's a very thinly veiled deference to the president. We don't know what it was that the Chief Justice was being thanked about as the president left the Congress, his joint address. but thank you. I won't forget, is what he said to the Chief Justice. I suspect that the immunity decision had something to do with that, although there's no way of knowing. But the immunity decision not only eliminates the fact that there were all these lawsuits, but as we know, getting elected took care of criminal law exposure by this president.
Yeah. Well, can you talk about the cocktail of the shadow docket you mentioned earlier and this whole notion of emergency after emergency after emergency? I don't know how many emergencies we've got going here, but that seems to sneak through on the shadow docket. What's going on?
Well, so the shadow docket to review the bidding is something that no one noticed very much, and it was where court actions could be followed if you were an insider to know what happened maybe to your case about when the briefs are due and whether the other side has done what they're supposed to do and so on. That's what the shadow docket was. It's kind of a scorekeeping, and cases would go on there and they would have time limits and so on. Uh, it has been the case, and there's a good book by Stephen Vladeck about this, that the shadow docket increasingly is the basis for the current court to say, oh, we better take this case. It's really pressing, it's really an emergency. And they take it without waiting for oral argument or for briefs. So they're in a big hurry to decide the case, not in the traditional way of having both sides express their views. And often the case will go away when it turns out they didn't really disagree, or those people have been released, or those people have died, or whatever it is. So all of a sudden, the shadow docket is not doing that, it is being a source for the court to grab something and say, oh, the government will be irredeemably injured. I mean, the case that I guess kind of stands out this term already is there's a case of California suing, and California says you've taken away some grants for teacher training. So it's the Department of Education, such as we still have it, versus California. And California and the lower courts all say, well, that's right. There were these grants, and now you're trying to just wipe out the grants that have already been given, which is now we know a pattern of people with or without chainsaws in their hands. Uh, that's what they've been doing. The fact that we've committed, that we were on paper obliged, doesn't matter. Why not? Because the government will be irredeemably injured. There's an emergency. And the court takes that case, and that's what they say. Now, government is not going to go broke. It's not that many grants. It's not that much money. The teachers, the school districts, they may be in an emergency situation, but they're not the ones who said it's an emergency. It was the government, the federal government, that said it was an emergency. Well, they got away with it. I don't understand it. It is not, in my view, any way to define the term emergency. Uh, But as I said, the Alien Act of 1798, the Alien Enemies Act, is what we are using to say, oh, there's an emergency on our borders. We are being invaded. Now, that clearly was about the French and the English and a time when the fragility of the new republic was very evident to people. So, who should we align with? Should we be neutral? Uh, Certainly, George Washington had something to say about that that was important. And that's what that statute's about. That's what it was about, because there had been bloody warfare on our territory, right? Called the American Revolution. It also sort of anticipated the War of 1812. That's part of the history we don't like to talk about, because we've always won our wars, except when the Capitol was burned in 1812, the War of 1812, I guess it was 1814. So that was, you didn't maybe lose the war, but you certainly didn't win the War of 1812. Nevertheless, we probably won't talk about that in schools anymore. So it was a time when, a fraught time, if you will, and there were enemies and there was fear of foreign invasion, as there has been since. But at that time, it was very lively fear. That's the statute that the president is using. It's unheard of until this president, except for real war. Whether or not real war has to be declared by Congress is a question for another day. And certainly the framers thought it did, but we have had a number of wars without a congressional declaration. But Where's the invasion? Define that for us, would you please? Uh, does it mean anyone we don't like? Where's the emergency? There's no filling in of the blanks. The blanks are what are allowing. And it's not just blanks when it comes to bullets, I'm afraid.
I was listening to Amicus, which is a podcast series on Slate Magazine,
Hmm.
including a judge by the name of Sugarman. Judge Sugarman was on there. Look how many emergencies we have. And it wasn't just war. It was one emergency after another. And they counted all the emergencies. There were at least half a dozen emergencies that the administration has claimed in these various cases. And you hear this podcast and you say, my God, I didn't know that we were in such a situation where there are half a dozen emergencies going on in the country, and I was not aware of any of them. And that's what we have here, and the court apparently buys that sort of thing.
Interestingly, our governor and his use of emergency power is before our Supreme Court. Now, there's an argument about whether Governor Green has gone too far, and he has used the emergency power a lot. Now, should those be different levels of review by appellate courts, by courts on appeal? Uh, we don't know when, if ever, the U.S. Supreme Court is going to worry about it, but our Supreme Court is going to worry about it. And our Supreme Court did a remarkable thing, I think, and it hasn't adequately been publicized. So in early March, not long into the Trump administration, when DEI and so on was being used as a very effective bludgeoning technique, our court said, wait a minute, we believe in access to justice and we believe in equity. And that's what we stand for. That's what our Constitution stands for. That's what our court stands for. They each signed it, each of our five justices. There was no case in which they did this. They just thought it was important to go on record about how different we are in Hawaii from what's going on over there. And I think we are blessed, whether you're religious or not, to be in Hawaii and have some distance. But it's affecting us, and it's going to affect us big time when it comes to medical research or the environment. There's no climate change, it turns out, because the president said so. Scientists and anthropologists and biologists think that race is a social construct. No, the Trump administration says, no, it's not. It's definable, it's inherent. People are born, and similarly with gender, by the way. So there are cases about whether or not you have to say there are two and only two genders, and it's really messing up people with their passports, for example. There's no emergency that leads to that. So what are we doing? What are we looking at? And why aren't we all out in the streets or writing op-eds or writing Congress? I mean, it's just an astonishing moment.
That's because Trump is flooding the zone. He's trying to obstruct and distract us in every way possible. So we can't keep up with him. But you know what? There's a similar process going on in the Supreme Court. This term has only a few weeks left, and they are sitting on 20 or 30 cases they haven't ruled on yet. And what we are probably going to see is at the end of the term, before they go off to their yacht trips in the South Pacific and the like, we'll see a whole according to the Amicus podcast, we'll see a whole bunch of cases flooding the zone at the last minute on a Friday afternoon, and then they're all gone. And the press is left scratching its head. What happened here? And I suspect that those cases will not be decisions that you and me will like at all. And it's the same process. It's flooding the zone. It's coming soon.
We have to, in part, and I guess maybe you could describe what we're talking about as trying to zone the flood. There's some the flood that you have to take part by part, and we're looking at one part of it, the constitutional law part of it, and some of the equities that go along with that, if I can use that term. So I think that's important, that we have to pay attention and find a focus rather than just say there's just too much and every day there's something new. The head of the portrait gallery is out. She didn't apparently get with the program. So the National Portrait Gallery head is out. The Library of Congress, it turns out, even though there are statutes, no, no, the president actually is in charge. And some of his people said, well, they don't have any books there. That's why. So their vision of a library, I guess, involves the kind of libraries we have here, where they're very helpful librarians. There's a children's library section. The Library of Congress is not like that. And in fact, it has every copyrighted book in the country. It has an obligation to have it. But they said, no, no, there are no books. So not really a librarian. Therefore, they didn't say off with their heads, but that is where we are. In terms, I think we have to look for shards of hope. And I found one in the birthright citizenship argument. Now, one cannot, I think, in general, with any confidence, say this is how they're going to come out. But that's such a clear violation of such an established principle that is blatantly in the text of the 14th Amendment and followed ever since 1868, including an important Chinese immigration case at the end of the 19th century, that one would think it is no surprise that the lower courts have all said, come on, birthright citizenship, there it is. It's got to be clear. It is clear. That's what we hold. So then the argument becomes one about how far the injunction can go. So that's kind of inside baseball, and it's called a universal injunction. And it's true they weren't around very much. It's true that they were then used against the Biden administration to say, for example, oh, no, you don't have authority, President, to do something like student loans. No, no, you can't do that. And the injunction from a particular judge in Texas they knew to go to. You find a district where you have one or two friendly judges, and that's where you sue. That's where you sue. So it's called forum shopping, and lawyers are pretty good at that. The current administration is being attacked in some jurisdictions where they don't want to be attacked, uh, in Massachusetts, in Maryland, in California. So, yeah, that's been going on. It's very hard to know what the alternative to the universal injunction is. The universal injunction says throughout the country, this opinion applies until someone reverses it, goes up on appeal. We see what happens. So the problem in that argument was largely about that. And Justice Sotomayor started off, I think, brilliantly by talking about the cases about birthright citizenship. Let's talk about the merits here, knowing that the argument was going to go also on universal uh, injunctions. So Justice Kagan, who is a proceduralist in many ways, asked a question which didn't really fully get answered. I don't think the Solicitor General was very effective on behalf of the government. And then Justice Barrett said, I want to go back to Justice uh, Kagan's argument or question, not argument. And she said, now we're trying to think of alternatives to this kind of injunction. So what if there's a decision in the Second Circuit that's a bunch of federal district courts are covered under one circuit court, Court of Appeals. Second Circuit is where New York is. It's some of the smaller states. And so the hypothetical is, so we have a case now in New York, and the Court of Appeals, the Second Circuit, has decided this case. Are you, the federal government, bound by that decision? So the government was sort of, the US government is kind of in a corner on this. Solicitor General Sauer says, generally. And she says, generally? What does that mean? Does that mean that's official Department of Justice policy that you just generally follow precedents? Or are you actually bound by lower court opinions unless the Supreme Court does something that orders you not to be? And he doesn't have an answer to that. So there's a shard of hope that if Justice Barrett sees the problem, they may actually get to birthright citizenship, and they may actually say what I think they have to say, which is, it's in there. You can't change the rules in midstream, wherever the horses are.
That's very worrisome to find that provision, which we've all known about and relied on for our whole lives. If that's struck, whether on procedure or substance, if that's no longer reliable, what happens to the country? What happened to the whole notion of citizenship? It's just a rhetorical question, Avi, but it's very troubling. Why is the Roberts Court doing this? Is it because Trump owns them? Has he got something on them? Is it transactional with him, or is it ideological, or is it a combination? But they're really off the side, case after case after case. And I have no confidence in anything they do. And I think a lot of people have completely lost confidence in that court, which means they have lost confidence in the judicial system, one of the three branches of government. We've already lost confidence in Congress, by the way. So, what drives them? What drives Roberts?
This is too complex a question, and I don't think we know yet fully. And I got to say, even as I've gone through some of those uh, what messy cases in terms of the procedures and some startling things that they were willing to do, Roberts has sometimes not joined, uh, and I think it's really only two justices who steadily always go for whatever they think Trump wants, and that's only two. So we have others in play, I suppose you could say. Um, so let me go back, for example, to one of the cases I was talking about, which is Trump versus JGG. And this was decided in early April. That's Judge Boasberg, the one I was talking about, who was the head of FISA special court. And that's a TRO, a temporary restraining order. And the court says, well, you shouldn't be using some other statutes. This is a challenge, not the statute about the alien enemies, in which habeas is the remedy you should use, which a lawyer can say, okay, I'll make the same argument in a different costume, as it were. Habeas corpus, very important, even in England, even back in the day, which used to matter to Justice Scalia, for example. Secondly, the claimants, the people who were saying there's a problem here, said it's not fair to just grab people off the street and send them to Texas, which happens to be where those sympathetic judges might be. So there's a question of where you can bring the lawsuit. And the court says, well, really, you probably are not allowed to challenge where it wound up, where the person is now, not where the person was picked off the streets. So venue, which place is the right place? Yeah, okay, the government has a point there. But then they say, there's got to be due process. There's got to be some hearing. Well, that's important. And it's pointed out, I think it's Kavanaugh who points out that that is what we are all saying. So we have 9 justices actually saying that. Now, my point is that we didn't follow that to this date. Other judges have, other lower court judges, and the lower court judges have been pretty terrific overall on these questions. They've been standing up, and they are, the journalists I think go overboard and say, oh, that was a Trump appointee, that was a Reagan appointee. It doesn't really matter who appoints, as we know, reminded by Justice Souter, who was a great disappointment, apparently, to the conservatives, because he was a independent-minded judge who respected the law, the fact-finding, the processes, and so he didn't always come out their way. The thing that is striking in the way you pose the question is that Trump just says, we're the only country in the world that has birthright citizenship. That's just wrong. I mean, and no, okay, but he gets away with it. I mean, he can just say whatever he wants. And even when it gets to a lower court judge, it doesn't matter. The judge says, wait a minute, that's not so. Here's some other country. I mean, the facts don't matter. History doesn't matter. What matters if it's not history and it's not the facts? The law relies on history and the facts at its best, and sometimes at its worst. We get bound by in ways that probably we shouldn't be, but they matter. You can't just say, we don't care what history says. We don't care what the facts of this case are. We just think this is the right thing to do. Judges are not supposed to do that. Neither is Congress and neither is the president, but certainly judges are not supposed to do that. And I think there is some hope that the judges have not all been saying that. And in fact, some of the judges, even those appointed by Trump, have begun standing up. I'm looking for hope, Jay.
I know you are, and I want to mention one other thing that will not give you hope, and that is the Department of Justice. It's actively involved in a lot of this litigation. It represents the United States of America. And Pam Bondi, who, a lot of constitutional lawyers would have no regard whatsoever for her, is controlling the people who go down to the Supreme Court building and argue in front of the Supreme Court on constitutional issues on behalf of the United States. There is nobody there, no other person there representing the United States, but Pam Bondi's designee from the Department the Department of Justice, who nobody can be confident of. This has this is like one hand clapping. So you have the court, which has some really strange membership these days and some strange ideas, and then you have the United States represented effectively by Trump, and they're making all these decisions in Trump's favor. Bizarre decisions. It's like, when are the people going to arrive?
Well, so in the case that we were talking about, Judge Boasberg's case, there was, oh, no, no, it's not that one. It's the Maryland. Oh, we made a mistake when we deported this person. The lawyer who actually said that was fired for saying it. It was the government position, but a lawyer working for Trump was not supposed to be honest with the court and was immediately fired by the Department of Justice. So it's a very important question about who is making decisions. That's why Justice Barrett's pinning down of the Solicitor General, I think, was important and revealing. Because are you really saying that you just decide whether you want to follow a precedent or not? That is not, shall we say, standard Department of Justice treatment of the law over its entire history. But that's apparently where we are now. So it's a really serious concern. And, it should be a concern about emoluments, for example. So someone tried to use that in the first Trump administration about renting the hotel that he and his family own for outrageous sums, including for the Secret Service and so on, making a lot of money off that. Someone said, wait a minute, you can't do that. The Constitution has this weird word, emoluments. I've been teaching constitutional law for decades and decades. I never think I ever mentioned emoluments unless we read the Constitution aloud together until the Trump administration. No one paid much attention to you shouldn't have emoluments. So now we can sort of understand what emoluments are, but there was no standing. The people who made that challenge couldn't come to court. Inside kind of theme, which is very important, practical terms, but hard to explain to the person in the street about what standing is about and who has it and who hasn't. And I would say the current court has not been consistent about that. It never is clear who has standing and who doesn't, but boy, they have really messed it up some if you want to pay attention to the rules of standing, which are at some level a constitutional access to court rule, minimum threshold, if you will. Okay, so no one had standing then. But now look at the Department of Justice, as you mentioned, the Attorney General, who had been lobbying for Qatar, it turns out, who now says, oh, it's okay to get that plane from Qatar. Sure, there's no emolument. And the Constitution doesn't just say emoluments, it makes sure there can't be foreign bribes. Well, where are we now? What about that black tie dinner and the people who came in? So the corruption, which we haven't even talked about, is astonishing and not embarrassing. It's both of those things. It's incredible.
Yes, it is. And it seems to me like we've lost so many provisions in the Constitution, so many statutes, rules of law, decisions, right, correct decisions of the judges. They've been cast aside. And so my last question to you, Avi, is it's a hard one, I'm afraid. Um, suppose suppose we have another court at some time in the future. Suppose we have a president who's not a Republican, not a Trumper, and who has the opportunity to appoint more liberal justices. How in the world do you reverse all these bad precedents, all these bad decisions? How long would it take? And if you had a Democratic Congress, I suppose that would be better. But let's not count on Congress. Let's just assume that the court has to fix, its own garden here. It has to fix all the fantastic, incredible decisions that have been made by this court, the Roberts Court. How would it go about doing that? How long would it take? Is it doable at all?
I don't think it is doable. And I think actually it's a issue with the law, even more generally than constitutional law, which is you are never really made whole when you are injured and you go to law. And they can give you a lot of money if it's a tort claim or a contracts claim. Uh, but they can't reverse what has happened, right? So even in the most simple case, there can be attempts at a remedy, but you can't fully make someone whole in whatever definition that is. Well, in these terms, there's no going back. We're never going to get all the way back to where we were. Uh, and I suppose there will be new problems, new technology, and lots of other things with your hypothetical. Let us hope the hypothetical comes about in the sense that we still have elections, which are being narrowed as to who can vote and where they can vote and how much clout they can have as voters. The role of administrative agencies is being changed radically by the current court. They're not the first to do that, but they're doing it much more radically. So, where are um, the avenues of authority and of power? Um, they're not going to be what they were. Now, this is perhaps a good thing and perhaps a bad thing because there were certainly terrible things being done by the U.S. Supreme Court in the years leading up to the Civil War. There were some very conservative things done by the court over time, which we tend to forget. Those of us who share a time in which we had our upbringing, such as we were brought up, were probably spoiled by the Warren Court. The Warren Court was exceptional. The court generally has been very conservative and very deferential, ironically, to the other branches. The big argument was about activist judges in our time. Were judges going too far to impose their own values? Uh, we don't worry about activist judges anymore, right? It's an activist president. This was not an issue. It was warned about by Eisenhower, for example, uh, but it's a whole new world. And it is true, some other presidents have stood up to the courts. Lincoln famously said not much on the theme, but did not abide by Chief Justice Taney's issuing of a habeas corpus. He didn't do anything against it. His position on Dred Scott Lincoln's was always the parties are bound by it. A radical idea these days. The parties are bound by the decision. But he said that doesn't mean the rest of us can't oppose Dred Scott. And the Taney court was adamant about federal law. There's a Wisconsin case, which is ironically relevant to the Wisconsin judge who's now in trouble with the federal government because she aided, allegedly, in the escape of an immigrant because ICE was in the building. Uh, that is echoing fugitive slave stuff. And the Wisconsin case, it's called Abelman versus Booth, was a case in which the Wisconsin Supreme Court issued a habeas saying you don't have to return someone alleged to be a fugitive slave. And Taney is very upset about that and says, who the hell do you think you are, state court? We're going to insist. The alleged slave by then was in Canada. So we have precedents on many sides of these cases, and we don't, in some ways, it's a blessing, go all the way back.
Canada. Why does the word Canada, why is it so attractive to so many people right now? Anyway, Avi, we'll have to leave it there. Thanks so much to our esteemed guest, Dean Avi Soifer, former dean of the William S. Richardson School of Law and a constitutional scholar. I'm Jay Fidell, host of Life in the Law. We've been engaging on what is left of the U.S. Constitution. Thanks to our viewers for watching. We'll see you again soon for the next one. Aloha. Aloha, Avi.
Thank you, Jay.